Hello, and welcome to Estate Planning with Caress Law. I am Tammi Caress, and you are listening to Navigating Estate Planning with Caress Law. And today we are talking about the revocable and irrevocable trust and a few of the differences between those two types of documents. And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this podcast is not legal advice. If you need legal advice or before acting or making any decision with anything talked about in the podcast, seek the counsel of an attorney. Thanks so much. I often have clients ask me about this, and I hope today will help clear up some of the confusion around these two documents. Before I get started, I really encourage you to go back and listen to my first episode if you haven't already. In there, I really talk about the revocable trust and what trusts are and how they're used. So that'll give you a lot of background that I think will be helpful for this episode. To give you just a little mini recap on what a trust is, it's a legal document. And it's a legal document created by the trustor. So we call that person the trust creator. Other jurisdictions call it a grantor or settlor. It's the same thing. We give title to the assets to the trustee. The trustee is responsible for safeguarding those assets and also carrying out the terms set forth in the trust document by the trustor. And they do that for the beneficiary. A revocable trust and an irrevocable trust always has those three parties. One of the differences are a revocable trust typically is one person or two where they are the trust creators, the trustors, the trustees, and also the beneficiary. An irrevocable trust, the trustor creates the trust, but the beneficiaries and the trustee typically are not the same person as the trustor. And that's because a trustor of of a revocable trust retains ownership of the assets owned by the trust throughout their lifetime. The trustor of an irrevocable trust gives up ownership. Okay, so it's as if they are giving an asset away and they have no control at that point what happens to it, except that by giving it to an irrevocable trust, the trustor did set forth how that asset is to be used. But the trustor cannot direct beyond what that trust document says on how the assets can be used for the trust beneficiary. To go a little bit further into the irrevocable trust, there are irrevocable trusts that are created, but they don't go into effect until a triggering event occurs. And usually this triggering event is the death of the trustor. We also call these types of trust testamentary trusts. I'm using that loosely because that term is more associated with a last will and testament, but it's the same thing here. An example is a person dies, they have written out in their will or their revocable trust what happens when they pass away. And part of it says, I put assets in trust for this beneficiary The assets can be used for these reasons. And when they turn a certain age, or maybe for their lifetime at their death, I direct the assets to go to this next beneficiary. So to give you a more specific example, minor beneficiaries, children, grandchildren, nieces, nephews. If you die and you want to give assets to a minor, it's always a good idea to set it up so that it goes into a trust for them until they reach an age where you are confident that they should be financially responsible to be able to inherit that asset and have control over it. So oftentimes we set up these kind of trusts for minors. A trustee is named to oversee those assets and use those assets for that beneficiary. But the minor beneficiary does not have control of those assets until the trust document says they have control. So we can set up these types of testamentary trust, which are irrevocable trust, now, but they don't go into effect until a person dies. And usually it's set up within a person's last will and testament, or it's set up within their revocable trust. An irrevocable trust can also be created and go into effect upon creation. And lots of those kind of trusts are, maybe we want to set up an educational trust for grandchildren. It can be a life insurance trust, and it's just an estate planning tool to minimize the overall estate tax burden when a person passes away. I'll probably have an episode on that, I'm sure. So again, they can be created now and go into effect now, or an irrevocable trust can be created now, but it will not go into effect until a triggering event, which is usually the death of the trustor. So the revocable trustor, for a revocable trust, they retain ownership of the assets. They have all the control over the assets. An irrevocable trust owner or trustor has no control. So with a revocable trust, having control means that the trustor can change or modify that revocable trust at any time. So for estate planning reasons, maybe a beneficiary, when you created your revocable trust, the beneficiary was 10 years old. Now it's 20 years later and they're now 30 years old. And we don't need to have all of these protective measures in the trust for them any longer. So we modify the terms. We update it. It's always good, by the way, to review your documents and update them every few years at a minimum. I would review them, or when a life change occurs. And that's just a side plug here because things change. With an irrevocable trust, the trustor cannot, or no one else cannot change the terms of the trust. And unless there's extreme circumstances, which involves the court, which makes things very expensive. But that's the primary difference between the control piece. So with an irrevocable trust, you literally are giving up control. It's as if you're saying, here, take my brand new car and I'm going to give it to this person and change the title into their name. And now there's nothing you can do about it. That's the irrevocable trust. You're taking an asset, you're giving it to the trustee, and once that's done, you can't get it back, except in very extreme circumstances. Okay, asset protection. A revocable trust provides no asset protection. Many people think, if I create a trust, it's going to be protected from any potential creditors I might have. That is not true. Just not true. And that's because the trustor can change and modify the terms of the trust, and they have complete control over the assets of that trust. Therefore, those assets can be reached by potential creditors. An irrevocable trust does have creditor protection for the trust's beneficiaries. Okay, so if you have a irresponsible beneficiary and you don't want to give them money outright at your death. Instead, you can say, well, they'll get it in trust. Someone else will manage it. That way I know that they're being provided for and cared for, but they don't have the control. That is an irrevocable trust, and we do that quite a lot. With that financially irresponsible beneficiary, if they have creditors, their creditors cannot reach those trust assets. And that's because that beneficiary is not an owner of that trust. They just are benefiting from it. If a beneficiary is in a car accident and then they're at fault, and now they're in the middle of a lawsuit over it, that plaintiff in a lawsuit cannot reach the irrevocable trust assets for the same reasons. It is not the beneficiary's asset. Yes, they benefit from it, but it's not their actual asset. So there is asset protection for irrevocable trusts. There is no asset protection for revocable trusts. Many people say, well, why don't I just put all my assets in an irrevocable trust and I'll be the beneficiary? That's because it just isn't allowed. And I'm using that. There are asset protection trusts that you can make for certain jurisdictions. But again, when you're doing that, you are giving up control. You don't have any control over those assets. So most people, when they realize that, say, oh, no, I don't want to do that. Okay, another big difference are taxes. And I am talking about estate taxes here. An estate tax is a tax assessed at death if a person owns their total asset value is over a certain amount. Now, every jurisdiction is different, so those amounts differ in jurisdictions. So in the state of Oregon, if you die and your estate gross value is over $1 million, you are subject to the Oregon estate tax. In Washington state, the threshold is $2.193 million. There is a federal level estate tax. Those estates need to be more than $12 million. Many people aren't there quite yet on the federal level, but many people are on the state level. Now, when we talk about the gross value, we are talking about real estate, life insurance, death benefit proceeds. Many people don't realize that the death benefit on life insurance that their beneficiaries receive at their death is actually included in the value of the gross estate. Retirement accounts are included in the value of the gross estate. Your IRAs, your 401ks, things like that. Brokerage accounts, banking accounts, vehicles, business interests, all of those are in your estate asset list, your estate bubble, if you will. So if the combined value is over that state level threshold or that federal level threshold, there is an estate tax. A revocable trust does not prevent or exclude the assets in that trust from being included in the trustor's gross estate. So therefore, anything in a revocable trust is subject to estate taxes. However, assets in an irrevocable trust are not included in the trustor's, the trust creator's gross estate. And that's because if it is created and goes into effect during the trustor's lifetime, that trustor has given up control of that asset. And by doing that, it is not included in their gross estate. So just to give you a recap on the revocable and irrevocable trusts, a revocable trust is a legal document. The trustor, trustee, and the lifetime beneficiary is typically the trustor. It's the same person. The trustor retains ownership of those assets. The trustor can modify that trust, change beneficiaries of that trust at any time while they have capacity. There's no asset protection with that revocable trust, and the assets in that trust are included in the trustor's gross estate for estate tax purposes when the trustor passes away. The irrevocable trust also has a trustor, trustee, and beneficiaries. Usually, the trustor is different than the trustee and the beneficiary of those irrevocable trusts. The trustor gives up control of the assets, and they are no longer owners of the assets given to that irrevocable trust. There is creditor protection for the beneficiaries of the irrevocable trust, and the assets in the irrevocable trust are not included in the trustor's gross estate when they die, and therefore they are not subject to the estate tax. And I think I jumped over this one, but the irrevocable trust cannot be modified and the terms cannot be changed except under extreme circumstances. I hope this is helpful in differentiating between the revocable and irrevocable trusts. I don't want to dissuade you from creating a revocable trust or at all. There are many good reasons to have a revocable trust. I just wanted to clear up some of the differences. I hope this episode is useful. I also have a blog on this topic that you can review. It's on my website, and the blog is the revocable and irrevocable trusts. What's the differences? And I'll have a link to that in my show notes below. The website also has lots of resources. It is www.caresslaw.estate, and that is CARESSLAW.ESTATE. I also have my other podcasts on that website. Look for our next content. And if you have any questions or if you have any ideas that you want to, or topics that you want to learn more about, please feel free to reach out to us. Thank you, and I hope you have a wonderful day.